Welcome to this podcast on the Right to Information Act. The Right to Information Act, or the RTI Act of 2005, is an act of the Parliament of India which sets out the rules and procedures regarding citizens' right to information. It replaced the former Freedom of Information Act 2002. Under the provisions of the RTI Act, any citizen of India may request information from a public authority or a body of the government or instrumentality of state, which is required to reply expeditiously or within 30 days. In case of matter involving a petitioner's life and liberty, the information has to be provided within 48 hours. The Act also requires every public authority to computerize their records for wide dissemination and to proactively publish certain categories of information so that the citizens need minimum recourse to request for information formally. The RTI bill was passed by Parliament of India on 15th June 2005 and came into force with effect from 12th October 2005. Every day on an average, over 4,800 RTI applications are filed. In the first 10 years of the commencement of the Act, over 17,500,000 applications had been filed. Although right to information is not included as a fundamental right in the Constitution of India, it protects the fundamental rights to freedom of expression and speech under Article 19(1)(a) and right to life and personal liberty under Article 21 guaranteed by the Constitution. The authorities under RTI Act 2005 are called public authorities. The Public Information Officer, or PIO, or the first appellate authority in the public authorities perform quasi-judicial function of deciding on the application and appeal respectively. This Act was enacted in order to consolidate the fundamental right in the Indian Constitution, freedom of speech. Since RTI is implicit in the right to freedom of speech and expression under Article 19 of the Indian Constitution, it is an implied fundamental right. Information disclosure in India had traditionally been restricted by the Official Secrets Act 1923 and various other special laws, which the new RTI Act overrides. Right to information codifies a fundamental right of the citizens of India. RTI has proven to be very useful, but is counteracted by the Whistleblowers Protection Act 2011. The Right to Information Amendment Bill 2019 seeks to amend Sections 13, 16 and 27 of the RTI Act. Section 13 of the original Act, it sets the term of the Central Chief Information Commissioner and Information Commissioners at 5 years or until the age of 65, whichever is earlier. Finally, in Ashwini K. Singh case on 20th September 2020, it stabilized that right to information is a fundamental right. Let's take a look at the scope of the Right to Information Act. The Right to Information Act extends to the whole of India. It covers all the constitutional authorities, including executive, legislature, and judiciary. Any institution or body established or constituted by an act of parliament or a state legislature. It is also defined in the Act that bodies or authorities established or constituted by order of notification of appropriate government, including bodies owned, controlled, or substantially financed by government, or non-government organizations substantially financed directly or indirectly by the funds, fall within the scope of the Right to Information Act. Private bodies. Private bodies are not within the RTI Act's scope. In a decision by Sarbjit Roy versus Delhi Electricity Regulatory Commission, the Central Information Commission also reaffirmed that privatized public utility companies fall within the purview of RTI. As of 2014, private institutions and NGOs receiving over 95% of their infrastructure funds from the government come under the Act. Political parties. The Central Information Commission (CIC) held that the political parties are public authorities and are answerable to citizens under the RTI Act. The CIC said that 7 national parties, Congress, BJP, NCP, CPI-M, CPI, and BSP and BJD has been substantially funded indirectly by the central government and have the character of public authorities under the RTI Act, as they perform public functions. But in August 2013, the government introduced a Right to Information Amendment Bill which would remove political parties from the scope of the law. Currently, no parties are under the RTI Act, and a case has been filed for bringing all political parties under it. The amendment. The Right to Information Act 2019, passed on July 25, 2019, modified the terms and conditions of services of the CIC and Information Commissioners at the center and in states. It had been criticized as watering down the independence of the Information Commissions. A Supreme Court of India judgment on 13th November 2019 upheld the decision of Delhi High Court, bringing the Office of Chief Justice of India under the purview of Right to Information Act. The governance and process. The Right to Information in India is governed by two major bodies: the Central Information Commission (CIC) and the State Information Commissions. For the CIC, the Chief Information Commissioner, who heads all the central departments and ministries with their own public information officers, are known as PIOs. CICs are directly under the President of India. For the State Public Information Officers, or SPIOs, they belong to the State Information Commissions. The SPIOs head over all the state department and ministries. The SPIO office is directly under the corresponding state governor. The State and Central Information Commissions are independent bodies, and Central Information Commission has no jurisdiction over the State Information Commission. Fees. A citizen who desires to seek some information from a public authority is required to send, along with the application, a postal order or demand draft or a banker's check, payable to the accounts officer of the public authority as fee prescribed for seeking information. If the person is from a disadvantaged community, he or she need not pay. The applicant may also be required to pay further fee towards the cost of providing the information, details of which shall be intimated to the applicant by the PIO or the Public Information Officer as prescribed by the RTI Act. Thank you very much for listening to this podcast on the Right to Information Act 2005.